General, because you kind of followed that, I think, a little bit. And thank you for being here too. Let's take it away, and we would again appreciate any thoughts and some catch up from your perspective on Senate File 40.
Thank you, Chairman. Committee, this is major. I've got a green light.
You got a green light?
I've got a green light. Is that better?
Oh,
Okay.
there you go. That helps us old guys.
Thank you, Chairman, and to the members of the committee. My name is Major Karen Hinkle. I'm the Staff Judge Advocate at the 153rd Airlift Wing, part of the Wyoming Air National Guard. And just to kind of talk about this bill in particular, the purpose of this is really to allow the Air National Guard and the Army National Guard to obtain information on members who are undergoing criminal investigations. And we use that for a variety of purposes, mostly administrative. It's really to ensure that we take appropriate follow-on actions with regard to security clearances and really employment status. And so this will enable us and assist us in getting those records.
Committee, any questions of the Major? Major, I've got a couple, I guess. I think what questions we may get upstairs if this bill passes the committee would be, what's the problem that we have now?
That's a great question, Chairman. It really depends on the jurisdiction that we're working with. Some jurisdictions are very cautious about providing certain law enforcement files to agencies that are not typically considered law enforcement. And where we often run into that has been with sexual assault cases or cases where there are really sensitive privacy interests associated with the victims. You know, in a personal experience, in a case that we adjudicated several years ago, we had to work very closely with the county attorney in order to authorize that release. Sometimes it's possible to work memorandums of agreement or understanding with agencies in order to facilitate that release of records, but that would require us to go to pretty much every law enforcement agency in every county in the state that has their own attorney to facilitate that. And it would be a little bit more efficacious, I think, to have a statute that authorizes that, and it would prevent the need to work it in the future every time we had a change in the administration.
So Major, I think one of the concerns that I heard back when this bill went through a little bit was that information may not be held tight, which was a little surprising to me, knowing that it's the military, for goodness sake. Is that a concern of yours? I mean, it's obviously in some jurisdictions, maybe a little bit of a concern for some of our local law enforcement, but it's not like that information is going to go anywhere except in a vault in our military department, right?
Mr. Chairman, so the information, usually that request would be facilitated either through our law enforcement arms of either branch or through the legal offices. And typically what happens is I request it directly as the JAG, and then my counterpart on the Army side does that as well. We do have to release it to individuals who have official need to know that information. So typically that's going to be individuals in the direct chain of command. We do limit that release. You know, if we have an administrative discharge board and that evidence is used in the process of going through that hearing, it would be released as evidence only to the members of that board. And so there is always, just like anytime anybody obtains a report, it could be disseminated outside of my immediate control, but there are restrictions and policies in place to try to limit that. Typically it's done to counsel, not directly to the individual, but if it's their case and they haven't a right to have that evidence, there are ways that they could obtain it. I don't personally have a concern that information would be put out there on the internet. It's possible, anything is possible, but historically we have not had that issue arise. And we have had some pretty sensitive cases that we've had to deal with and distribute evidence in order to continue with whatever actions we needed to take.
Well, that certainly is not the intention of this bill at all. And so, you know, the final question I've got, and then I think Senator Pappas has one too, Major, is Well, let's go to Senator Pappas. You go ahead.
Yeah, my question is whether in the past there's been some incidents where you needed this information and couldn't get it. Has there been, how often does that happen?
Major, go ahead.
Mr. Chairman and Senator Pappas, to answer your question, it really depends on the jurisdiction that we're working with. And one of the unique challenges for the Wyoming Guard in particular, we have members that reside in many different states. And so this bill really only addresses investigations that take place in Wyoming. We have been working very hard to develop good working relationships with district attorneys and law enforcement agencies across the state. Sometimes in areas where we may not be as well known, I think that it might be a little bit more concerning for those folks if it's the first time they've had to engage with us. So it would be a little bit of a prophylactic measure. But I haven't had an incident recently where that's been an issue. In the past, it has been, but we've been able to repair a lot of those relationships.
So this is just a 30,000-foot view question. Are you comfortable with the language in this bill, and does it do what you need it to do?
Mr. Chairman, looking through it, I think it gives broad enough authority for us to obtain the records that we need. I think it gets us there.
Okay. And if we spot something in the next little bit of time, you'd sure get back to us, wouldn't you?
Mr. Chairman, absolutely.
Okay, good deal. And
Mr.
you
Chairman?
got some backup back there. Senator Anderson.
Mr. Chairman, I think what I heard the last time was on page 2, on line 7, it was including any completed investigations. And then on page 3, line 7, it's repeated again, completed investigations. And I think what I heard was that they were concerned that we would go back 30 years on somebody and make some kind of a irrational decision based on what they did 30 years ago. Have you got any answers for that we could use?
Major, what say you on that concern?
Mr. Chairman, thank you. Senator Anderson, if we don't have jurisdiction over somebody 30 years ago, we're going to have no need to dig back that far into the records. We're really only talking about things that impact our current members for which we have pressing actions that we may need to take. Current investigations of that nature. So we don't necessarily need to go back in the past and look for that information unless it was raised in a current issue. Does that answer your question, sir?
Well, it doesn't help me to explain it on the floor. It's any completed investigation. So I was assuming that I could have a investigation 5 years ago or 10 years ago, and that would be a completed investigation that you'd want to hear about. Is that correct?
Go ahead.
Mr. Chairman, Senator Anderson, so I didn't draft that particular language. What I consider a completed investigation is one that I can use to further an action. And so it's really designed to make sure that I don't take a partial investigation where law enforcement hasn't conducted or concluded their activities to make sure I got the entire file.
Okay. Thank you.
So Major, that brings a question to my mind, which is, again, we're trying to cover some bases for questions we may get, which is, okay, so we give the permission to our military department to get this information. Why do you need it? Can you give me just a general sort of case that might exist, and this is why this might be helpful?
Mr. Chairman, I absolutely can. And this is purely and completely hypothetical.
Sure.
Let's say we had a member who was investigated for an internet crime, and we were not provided a copy of the investigative file in order to conclude any of our administrative actions, such as evaluating their security clearance to top secret information. If that was close held by civilian law enforcement, we would be precluded from taking that without conducting our own internal investigation. And frankly, that would fall well outside of our law enforcement jurisdiction to do that. So it really does hamstring us in protecting national security and in affecting employment actions and taking on necessary measures that we need to when folks have that kind of issue going on.
Okay. Yeah. Thank you. Committee, anything else for Military Department. Senator Anderson.
Mr. Chairman. Mr. Chairman, yeah, one more thing. This only allows you to do that for Wyoming. But like you said, you have a lot of your soldiers are out of Colorado or somewhere else. So this would not be an investigation into a Colorado person or anything like that. This is strictly what has happened in Wyoming.
Go ahead.
Mr. Chairman, Senator Anderson, this would only control, right, the release of information that's owned by Wyoming law enforcement agencies. So we would still have to go through and work through on a case by case basis issues with other states. And we've got cases where that happens from time to time. And usually those investigations or those law enforcement agencies are willing to work with us. It's just something we'll have to do.
So Major, if you think it would help, we could write Nebraska and Colorado into this bill.
That'd be great, Mr. Chairman.
Yeah, we'll just tell, there you go. We'll just tell them that they've got to give the information to us.
Give it a.
There you go. Senator, go ahead.
Yeah, well, I see this. I mean, it's already in statute that they have the ability to obtain these criminal records for employees, for prospective employees and volunteers. So we're just extending this to the military members, correct? So we've already got it for a segment of people that are working for the Wyoming Military Department. We're just now including the military members. And there's also a limitation of, if you look at the the bottom half of Romanet, what is that, 15? There's only for certain purposes that you can get this information. So I think it's pretty, I mean, it gives them authority to make sure that all members are covered. But there's some sideboards on there too. So I think it's good.
Okay, thank you, Senator. Appreciate that. Anything else, committee, for our Senator Furphy?
Thank you, Mr. Chairman. This may not be such a question for them, but on page 2, very top, it says criminal history information shall be disseminated by the agencies. How do we require them to disseminate that information?
Go ahead. Major.
Mr. Chairman, and Senator Furphy, when you say how, do you mean the methods by which they would disseminate it?
Go ahead,
It
Senator.
seems to me, and thank you. So you've got a candidate for a position. And so do you go out to each of these agencies and ask them? Is that how you do it? So it's not necessarily fingerprinting that creates that situation. You actually go out to all of the agencies yourself.
Mr. Chairman, thank you. Senator Furphy, typically what happens is we get notified that either from the member themselves, they have an obligation to notify us if they are arrested or if they're undergoing an investigation. That will prompt us to seek the records once we know that that investigation is complete. So typically, yes, we just facilitate that communication between typically my office and either the sheriff's department or the county attorney or the district attorney, depending on who owns the case at that time.
Yeah. Okay, committee, anything else? Appreciate that conversation, Major. Thank you. It helps us to get caught back up on this bill a little bit. And, I think it's important. And so we want to take good care of it as it moves forward. So I would ask you again, if you decide something tonight and you think, oh, I wish I'd have changed on page 3 something, please let us know. And we'll work the bill all the way through the process. Okay, thank you very much. I'm going to let you guys step back for a minute and I invite any public comment on Senate File 40. Senate File 40 is criminal record dissemination by the military department or for the military department, Senate File 40. Any public comment? Would anyone like to come forward and testify on Senate File 40? Do we have anybody online tonight?
No,
Yes,
Mr.
we will-
Chairman, there's no
to
one in the waiting
testify,
room at
Donna?
this point.
All right, thank you very much. Okay, I'm going to close public testimony. Committee, what's your pleasure on Senate File 40?
Move the bill.
Okay, moved to Anderson,
Second.
seconded by Senator Furphy. Let's work the bill, gentlemen. Page 1. We're just amending statutes that were referenced by Senator Pappas a few minutes ago. And, Page 2.
Page 2, Mr. Chairman, I think we might need Senator Pappas to help us with that completed investigations. I bet that makes some confusion.
Why is that?
That
That,
does excuse me.
yeah,
That's what I'm thinking. It doesn't confuse you and you can explain it. I think you can. I don't know that I can explain it yet. To
Anything,
the
committee?
satisfaction of the Senate.
I'm just going back over this language carefully, just to. Okay, and on
Yep.
3, you can see we're adding active duty or Wyoming National Guard military members. Okay? That's what we're doing in this bill. So,
Mr.
top-
Chairman, that is current
sir.
language that submit to fingerprinting. Is
Yeah.
that current language? We're not adding that.
That's correct. And the language in paragraph A at the top of page 2, that's current language. See? And so only the underlined, what we're doing is adding, to these 2 statutes.
Yeah.
And so that kind of helps to explain, this is already in existence. What we're doing is expanding it a little bit to give our military the opportunity to be able to look into situations that might arise. Okay. And I think that's important for all of us to be ready to explain and defend that on the floor. I think this is an important bill. So,
Let me ask you this,
Senator
Mr.
Anderson,
Chairman,
yeah.
and I think Senator Pappas probably knows this, but aren't those guys fingerprinted anyway? We're saying they should be required to submit fingerprinting in order to obtain state and national. Doesn't the military have a fingerprint on everybody? I thought they did.
They do.
So would they need to do it again? To get that from the state and national, or could they just use the existing fingerprints?
You could ask the military.
one of you two, would you mind coming forward and having another visit with us? Major, thanks for coming up here.
My
Thank you
pleasure,
very
Mr.
much.
Chairman.
So what about Senator Anderson's question?
Chairman and Senator Anderson, yes, we do have to get fingerprinted just as a condition of our military affiliation. Really, this is just adding into the requirement that's already existing in statute to allow us to get investigative files when we have members that are undergoing some kind of civilian law enforcement activity. So it doesn't add any additional requirement on the fingerprinting side.
So Senator Pappas, go ahead.
Well, if you recall, if you look at the original language was actually fingerprinting volunteers and employees, and they don't necessarily, military members get fingerprinted
Yeah.
when they join.
Yeah.
But I think since in order to make everything read correctly, since we're changing everything and including the military in Romanet 15 on section, what is it? 119, 106, that I think we have to follow through on this section as well and include the language of active duty military as well. Even though they're already fingerprinted, I think it would just be, we need to keep them in both sections.
So Senator Anderson, does that help? I mean, subparagraph A on page 2, the following persons shall be required to submit to fingerprinting. in order to obtain state and national criminal history record information. That really, should that read in order for the military department to obtain state and national records? It's not like the person is trying to obtain state and national criminal history records, is it? Thank you, Mr. Smith. Tell me about that paragraph. Why am I struggling with that language there?
Mr. Chairman, I'm Chris Smith, Senior Counsel for the Wyoming Military Department. The 719-201 at the bottom of page 2 onto page 3 of the bill. The bottom language on page 2, again, this is an existing statute.
Right.
There are 14 other entities before you get to the military department in the existing statute that can ask for these things. So the language on line 19 on page 2, that's the standard language covering a variety of things that are in the existing statute, not just the military department. On page 3, the language that was added on lines 2 and 3 to add in the active duty and guard. In talking with LSO, we were contemplating that there's a federal fingerprint system, and then there is a fingerprint for purposes of the National Criminal Index Computer System, the NCIC, which is what they check your background on. And so we were thinking it's possible that a member of the National Guard would have to resubmit fingerprints because they're not in the right system that the NCIC checks. So it was kind of as one person described it, it's kind of a belt and suspenders kind of thing. If the language wasn't there, we're probably fine. In terms of lines 2 and 3, adding active duty and National Guard members, we had to have the current law for prospective employees, as Senator Pappas mentioned, because we may not have their fingerprints because they're not our employees yet for background checks. So I don't know if that helps. The last thing I was just going to add, and Major Hinkle did a great job, but the reason we talked about completed investigations is when we did this, drafted this bill and talked to some of our law enforcement partners. Law enforcement sentiment from when they're ongoing, it's an ongoing, not completed investigation. So we wanted to be sure that we were only talking about completed investigations, not any investigation. Because if they're currently doing it, the law enforcement agency, let's say Cheyenne Police Department, we don't want them to give us that. They shouldn't give us that because that's their business. We only want the completed ones. And so that was really trying to limit it to only what they're done with and not so we're getting into their investigative function, basically.
Yeah, you can understand why agencies would be reluctant in an ongoing investigation. That's just not going to happen, right?
Right.
Yeah. Senator Pappas.
Well, then that confuses me a little bit. Then if we go to lines 5 through 6 on page 2, the military department for purposes of obtaining criminal record information, including any completed investigations. Maybe when you're using the word including completed, to me, it tells me that it's also allowing for non-completed investigations. When you say including, because that maybe it should say something more specific, like only completed investigations. You're the
I should have let Major Hinkle come back up here.
I mean, in my mind, am I wrong?
Well, she's welcome. I mean, we can,
The more the merrier.
yeah, you better believe it.
Mr. Chairman, in answer to Senator Pappas's question. So again, we're taking an existing statute, and that's part of what this is. For purposes of obtaining criminal history record information, that's like who's been arrested, who's been convicted. That's all that is. We wanted to specifically include completed investigations because for our purposes, there have been times, and I can give one example. There have been times when the law enforcement part is done. It's not part of the criminal history record information because there isn't necessarily been an arrest yet. The prosecuting attorney for the county or the district attorney has not yet made a determination what to do with that completed investigation, whether to put a warrant out for an arrest. But we want to know because they're up for deployment or they have a high level of security clearance. And if they're facing criminal charges, that's one of the security risks people who are facing a criminal action. So we want to pull their access to high level security information. Even though the district attorney or prosecuting attorney may not be there yet, they haven't arrested them yet. So that's what we were trying to do. I'm not sure I've answered Senator Pappas's question, but that was our main concern.
Yeah, thank you, Chris. That was great. Yes, that did answer my question, and so I'm comfortable now with it.
Okay. Mr. Smith, thank you. That is helpful.
Yes, Mr.
Very
Chairman.
good. Okay, so. Sure, I'll allow that. Bill, come on up. This is an ongoing deal and I don't mind having a little more public comment. Jump right in.
Mr. Chairman, Bill Winnie, Sublette County. Across my career in the Navy, I had multiple security investigations. Some of them are reinvestigations they do periodically. And every time they took fingerprints. And when you ask the people, you know, you've got my fingerprints, what do you want? And the answer is, when you get into that highly classified stuff, different than perhaps what you're talking here, that's one of their checks to make sure you're still the same person.
Gotcha.
So
Sure.
current fingerprints compared to old fingerprints answer that question too. I believe that gets to your question, Senator Pappas.
Bill, that's helpful. Thank you. Appreciate it. So back to the bottom of page 2 and on over to page 3. Are we nearing getting our arms around this one, committee? I don't like that language at the bottom of page 2, but I don't think, I mean, that's existing language in the statutes right now. And I don't think it actually is a good sentence. It reads as though I'm looking to get my state and national criminal history records. Not that you're going to fingerprint me so that the state can get it.
It's there.
But it's there. We're not going to do it. So are we good with this, committee? You all set?
Answer the question.
Kim, would you take roll on Senate File 40, please?
Senate File 40, Senator Anderson.
Aye.
Senator Furphy.
Aye.
Senator McEwen.
Aye.
Senator Pappas.
Aye.
Chairman Landon.
Aye.
5 ayes do pass.
Is anybody, just breaking the tape, trying to get to this one to take it? Senator Pappas, thank you.
Pappas would be good.
Thank you very much, Senator. And again, we will back you up, won't we, committee?
You bet.
We're right there if
Happy
the fight
about
breaks
it.
out, I'll tell you that. Okay, the next bill for our consideration is Senate File 13, another bill that has been around a little bit that was taken up again during the interim. Senate File 13 is temporary delegation of parental authority. And we worked this bill during the interim and look forward, Major, to your comments and thoughts on this. It did not get a unanimous introduction, and it was a couple of your colleagues in the legal profession that seemed to have some struggles with this. So maybe we can drill down a little bit tonight and find out what that might be. So Major, take it away. Thanks.
Thank you, Mr. Chairman. Members of the committee, just to refresh your memory, this bill is a proposal to allow by statute parents to delegate their parental authority on a temporary basis not to exceed 2 years for their children for a variety of purposes. For the military department in particular, this is useful because when we have parents deploy, obviously they're not there hands-on to take care of issues that might affect their children. And so we routinely draft powers of attorney in order to enable parents to designate a specific individual to either take care of medical decisions or educational or so on. It does not usurp a natural parent's authority as long as that hasn't been stripped by court order. So it doesn't supersede any existing court orders. It's just a tool that allows different institutions to have some confidence that a person who's making some decisions has the authority to do that.
So Major, where is the part of the bill that assures me that it does not usurp that natural right that someone has over their children?
And Mr. Chairman, if you give me just a moment here to make sure I get the right language.
I didn't mean to throw you a curveball, but I think that's one of the pieces that we need to drill down on. And
If you, and I don't have the same version that you have, so I apologize for that. But if you look in 32401, paragraph C1, in the middle of that, it discusses if the parents share legal custody and only one delegates rights, the delegation will only affect the delegating parent's own parental authority regarding care and custody of the child, and then so on. Essentially, they're unable to delegate away authority that they themselves do not have.
that's a pretty substantial paragraph, committee, and that does spell out exactly, I think, what we're talking about here.
Mr. Chairman, is that on page 2?
Page 2 at the
I,
bottom
yeah,
in
at the
C,
bottom. Is that
yeah, Romanet
Yeah.
I.
one that
Uh-huh. And
cover that?
so committee, just to Major, please stay put. We're just, you know, as we look back to this bill, you might recall 2 years ago, came through one of our senators upstairs and was really a request from one of his constituents up in Sheridan County. And, you know, the bill was worked a little bit, and I think it ended up in the Judiciary Committee and maybe stopped at that point. At which time the senator asked if we would be willing to take it up. And certainly I was, because I actually thought the bill had some merit, but so that's how we got to the interim with this bill. And then, of course, we worked it. I think this received a unanimous vote from our joint committee. So Major, I guess I'll ask you a hypothetical, which is hard for you to answer, but if there are concerns in the legal community, any guesses as to what questions we might get on that front? Be
Mr.
the concern over that we just talked about?
Mr. Chairman, I think one of the questions, at least that I've heard, is do we actually need a statute to serve this purpose? Historically, common law has authorized this kind of delegation for, well, as long as I've been alive. So it may not be a requirement to actually put this in statute. My observation about that is that I don't know that everybody who practices law is on the same page regarding that. And anytime you have an opportunity to clarify the time limits that are allowed, or even the circumstances under which things might apply, could be beneficial. Sometimes those can also raise questions. So really a benefit of this, if it were to move forward, would to be to ensure that every practitioner of law in the state is under the same set of beliefs about what is permitted.
Ready? Anything else? Makes sense. Yeah, the common law thing. And would that normally in a common world with common law, you would have a document of some kind that I would just, maybe a letter saying to the leadership of our military department, you know, when you send me over to Afghanistan, I'm gonna let Senator Anderson take care of my dog, right?
Mr. Chairman, I don't know that common law prescribes a particular format, but a letter could be sufficient. We in the military service have a pretty specific form that we use that's more or less universally recognized as a power of attorney or a delegation of parental authority. So it includes some language that's standardized across the services in terms of what exactly they're delegating and how long it's effective and whether it can be revoked in writing or so on. And so it's nice to have kind of that standard template with all of those guarantees. Common law doesn't necessarily prescribe all of those requirements.
Senator McKeon.
Mr. Chairman, I'm trying to wrap my brain around this. Don't we already have a process for powers of attorney? And are not those legal documents? So, and kind of a rhetorical question, but before you deploy somebody, you do all the pre-deployment training and you do all the powers of attorney. So my question is, are we creating another statute that's just redundant and really doesn't help anything out? Thank you, Mr. Chairman.
Major?
Mr. Chairman, as to your question, Senator McEwen, I think this all arose because there was some understanding by a practitioner in the state that a power of attorney could not be granted because it wasn't specifically codified in Wyoming statute, even though it is allowed under common law. So the benefit of a statute like this is that it clarifies that Wyoming law does recognize the delegation of parental authority. We do in the military have a process to set these up. It's a very routine part of our business. But whenever I hear, even if it's accidentally erroneous, guidance saying that somebody can't do it because it's not in the state law, that concerns me, because then I don't have the ability to tell my deployers this document should take care of all the needs that you might have for your children while you're away. So I do see some benefit in having it, even though common law authorizes the practice, if for no other reason than just to, again, get everybody on the same page about how long it would be effective, what any limitations are, how it works in tangent with court orders that might affect somebody's parental authority in those means.
Senator, go ahead. You bet.
Thank you, Mr. Chairman. As we look at powers of attorney, though, we're also talking about contractual law, are we not? Thank you, Mr. Chairman.
Mr. Chairman and Senator McEwen, I suppose it is kind of a contract, but it's really just me saying I'm authorizing you to take a particular action. I get to revoke it whenever I want. There's not necessarily a payment of in exchange for goods or services. It's just a document that captures my permission for somebody to take on the role that I would have as a parent. So it's similar in that it sets out some roles and responsibilities, but it's not like a barter or an exchange for a service.
Go on, Senator. You good? Follow up?
Thank you, Mr. Chairman. I guess what I'm saying at the end of the day, here's what this feels like to me. This feels like judges and lawyers are going to make decisions for parents and their children and getting involved. So we're going to make a law so they can't. I don't have a problem with the statute or the bill as it's written. I have a problem that we have to do this. At some point in time, Mr. Chairman, when do we have to quit asking for permission to take care of our own children when we probably know best how to do it? And I'll get off my soapbox here shortly.
Senator, I appreciate that. And I think that's exactly the conversation as we work this bill, our committee, let's bat that around a little bit, because I totally get that. My first reaction to this bill, and I'm looking at the major to see if I'm correct, I actually saw this as just an assurance to our military members that they can do this and that we're going to back them up when they do. No confusion if it's a common law situation and some attorneys, saying, well, maybe that's not what we have in a particular document and you can't change your mind. Is that a perspective that's on base, Major, what I just said?
Mr. Chairman, I don't know that most of our members who rely on these are worried that they won't be effective just because it's something they have to do and they just get it and it goes in their file and they're happy about it. Really, I guess from Karen Hinkle's perspective, just as somebody who works through these on a regular basis, the advantage of a statute really is just to ensure that everybody is under the same set of expectations, that when delegations of authority occur, they're all under the same understanding as to what the time limits are and the methods by which they can be approved or revoked, and all of the things that go along in it. Whereas if we don't have that, then I think there's always room for questions that get to what Senator McEwen is concerned about. What is it exactly that we can do, and why can't we take care of the kids in the way we see fit? This is really just providing a uniform mechanism for the parents to express those wishes.
Yeah. General? I don't mean to be ignoring you, but
Mr.
Major's
Chairman,
doing
you're
such a
ignoring
great
me for,
job. I just, you know.
yes, sir. You're ignoring me for the right reasons. That's for sure, sir. I just wanted to remind us that originally when this bill came forward, was not about the military at all. The original language had a restriction of 6 months on it. And that's what got the military's interest because of our deployment times. We thought that would certainly hinder us. So it wasn't an interest on the military side at the very beginning. We had really no play in this other than we thought that 6-month restriction would have been problematic as we deploy. So if you recall, the discussion then was, hey, listen, why don't you help us, military department, craft something that will not damage you or hurt your folks? So I think it is a good question that Senator brings up in the committee debates about whether it's necessary or not. As Major Hinkle pointed out, it's probably good to be clear, but our primary concern at the military department was that the bill not infringe upon some of our mobilization actions and cause us that issue. Not that we have necessarily a vested interest in figuring out parental authority at all and how that goes. But just wanted to kind of bring that history back. It was the 6 months originally that got our attention, and then that's how we became to be involved in this particular bit of legislation.
Appreciate that, General, that's helpful
Yes, sir. Thank you.
to help us recall that. And so, Committee, anything else for our military friends? I guess if you don't mind staying put for just a little bit longer, we'll continue to take a look at this. Committee, anything? We're going to go to public input if we don't have anything else, committee, I'm going to go that way. Okay. Okay, temporary delegation of parental authority, Senate File 13, and to our military folks, I'm going to go to public testimony and reserve the right to ask you to come back. Okay. All right. Does anybody, Mr. Winnie, come on forward, my friend. It's good to see you.
Mr. Chairman, pleasure to be here. Bill Winnie, Sublette County. I wanted to offer a little bit of perspective, particularly in light of Senator McCown's questions across my career. As I look at Section 2B, 2 years for the military people seems legitimate, but I would offer you might consider an ability to extend that. In some states, they have driver's licenses. As long as you're on active duty, a driver's license is good till you return to the state. I don't know how that might be worded, but you get the idea. You might look at it if somebody is sent overseas on short notice, on competent orders, as long as those orders remain in effect. If they go beyond 2 years, the time limit doesn't apply or something like that. One of the reasons I say that, I don't know how the Army or the Air Force works it, but in the Navy, you can literally be handed a set of orders that says proceed within 12 hours. And so things like the pre-deployment stuff that Senator McCown spoke to, maybe you have one in the works over at Legal Services, but now you're gone before it's done. And so the ability to write a letter is important. And I remember back in 1979 when we had the thing in Iran, the aircraft carriers and submarines being nuclear powered were sent overseas, and they stayed at sea literally for 10, 11, and 12 months before they ever hit another port, because they could, because of the nuclear propulsion. So you've got those kind of things to wrap up in the bill. The other thing you might consider, make sure it covers things like natural disasters. I recall in 79 when 87, when Hurricane Hugo came through Charleston, South Carolina, the electric grid was destroyed for 150 miles around. My kids' grandparents, my parents-in-law, came down, picked up the kids, took them back to Maryland, and they were there for like 10 weeks before Charleston, South Carolina recovered. So if a natural disaster occurs, again, you might consider a few words in there that'll enable that to be covered. And that thing about getting getting orders within 12 hours. A ship can get orders much quicker than that. I was a duty officer on board USS Hammerhead one time, young Lieutenant JG. Sunday night, 9:30 at night, CO calls me, says, get the ship ready. We're getting underway as soon as we're ready to go. Recall the crew. We ended up getting underway the next morning at 7:30, but you get the idea. And once again, that issue of pre-deployment stuff that Senator McCown spoke to could get short-circuited. So those abilities to be flexible, I think, is important for the legislature to put in place so that the judges, if they get involved, can do what you want them to be able to do for those military members. I have a son that's a National Guardsman. His wife is an Air Guardsman. I have a child and another on the way, and they could be picked up in that. You know, we're so used to peacetime over these past 50 years that we think in terms of pre-deployment stuff, but the reason they put the Soldiers and Sailors Civil Relief Act many, many years ago in place was very simply, you can be gone in a few hours in the military. Subject to your questions, Mr. Chairman, thank you.
Thank you, Mr. Winnie. Appreciate it. Any questions? Okay, thanks, Bill. Would anyone else like to testify on Senate File 13? Oh, please come forward. Thank you. Good evening. If you could state your name and
Good evening, Mr. Chairman, members of the committee. My name is Beth Lance. I am an attorney with the Wyoming Trial Lawyers Association. Our members, which consist of several family law attorneys, have reviewed this piece of legislation, and we do have just a few concerns to bring before the committee today.
well, then that's good to have you here. Yeah.
Well, thank you for having me. So I first want to say I completely understand the military's position, obviously very unique circumstances that warrant a need for them specifically, right, to be able to properly care for their children when they are in a deployment situation. So certainly understand why this has been created, but there are a few pieces to this particular piece of legislation that I'm concerned might be missing. And I think it's important to understand this legislation applies to all citizens of Wyoming, so not just the military. And so we would be allowing all kinds of our single parents to be able to start effectuating this document. So I think it's important to think of the different circumstances that may arise for those people as well. First, the concern is that there's no requirement in this bill to notify the other parent. And so I think the concern is that someone would sign on their own this document, and let's just say they delegate that authority maybe to grandma and grandpa, right? That might be a common person to delegate that authority to. But then there's no requirement that the other parent be notified. And while C1 of this bill does allow that parent to continue maybe whatever visitation has been established under their ongoing custody arrangement and decree, the law would really dictate that in the absence of a parent, the other parent should actually be the one to have custody over a grandparent, because we consider parental rights fundamental constitutional rights. And so certainly would want that other parent to obviously take over that primary custodial arrangement in that situation over a grandparent. And if they don't even have to be notified and they don't even know that grandma and grandpa now have child or children, I think that's a concern. The other thing here too is there's certainly no consent of the other parent. And so that's a concern as well. Obviously, we hope always that parents make good decisions for their kids. But I think these kinds of decisions should be made between both parents. And there's no requirement here for any kind of consent or notice of that other parent. So again, that's concerning, I think. Under current Wyoming law, I know there was a question, Mr. Chair, from Senator McEwen. What do we currently have in Wyoming? And what we have is we have guardianship laws. And those guardianship laws very clearly require notice to the other parent. And I think that's important. Our guardianship laws also can work very quickly. An emergency guardianship can be obtained within 72 hours, potentially faster if both parents are consenting and signing off. And so it certainly can happen very quickly. I understand that would be necessary in some cases for military members, and that definitely can occur under our current law. Temporary guardianships can be granted by the courts for up to a year, and permanent guardianships, as long as they need to be permanent, can be permanent, can be the life of the child until they reach the age of majority. So there are mechanisms within the law right now which essentially do this. They grant that parental authority to someone who is not a parent. But my concern with this power of attorney is that you may be granting a parental authority to someone who's not a parent when the parent is actually who should be the one to step in these situations.
Senator, go ahead.
Mr. Chairman, my question is, if I'm a single parent and I have another parent and I get chosen for deployment and I do power of attorney or however we work this out and send the child somewhere other than the parent, haven't I already broken the law? I mean, I'm going to tell you, when I was in command and parents got divorces, even back then, if one did not include the other parent or go to the other parent first, they've violated a court order. Unless the judge says you as parent B have no parental rights. And here's my question. If a judge has already declared somebody not to have parental rights and I get deployed or I have to go do something, does that reverse the judge's decision?
So I'm
Thank you, Mr.
turning to
Chairman.
my attorney friend. And Beth, what about that one? The senator asked a good question about the law. So take it away.
Thank you, Mr. Chairman. Senator McEwen. Obviously, if someone does not have parental rights, none of this is an issue for that person. That is not a person that needs to be notified. If they are completely devoid of parental rights, then for all intents and purposes legally, then no, notice would not be required under the law to that person under this circumstance or any other. So just to make that clear. As far as the idea that someone would delegate this parental authority without contacting the other parent, it would depend on what their decree actually said. What does their decree say? And well, I would certainly say that that would be a best practice. My concern is this statute would not alert them to that need or the necessity of doing such. And if that current decree is all that parent knows, if they just know maybe they're a parent that doesn't get a lot of time with their child, maybe they live in another state, maybe they won't see their child for 6 months because they're not going to pick them up till summer, right? Maybe they just have their children over the course of the summer or an arrangement such as that. Well, that child at that point could have been 9 months with grandma and grandpa. And then they go to get their child at summer and that's their first notice that that's what's going on. That's, I think, the concern.
So go ahead, Senator McEwen.
I guess my point is, and I'm going to shift gears on this. we want to pass, let's say, gun bills. People can't have guns if they're a felony. And as soon as many felons get out of prison, the first thing they go do is get a gun. And as we work through this, I guess my point is we put the language in there, but in my mind, it's already covered because they're doing something they're not supposed to be doing and they know what it is. Ignorance is not a defense of the law anymore, is it? Thank you, Mr. Chairman.
Beth, I'm not sure there was a question there but if the senator has a question on that front and can restate it, I'll sure let you do that, Senator. Thank you. I get your point though. And I was just leaning over offline here, Beth, to indicate that to Senator Pappas, I think we can move some of those elements into this bill if that's a concern. Senator Pappas, go ahead.
Yeah, I don't have an issue with notification if as long as there's shared custody. Then I think it's okay to make notification. But as far as the delegation as it on page 3 is only affects the delegating parents' own rights, right? Only that portion that the courts have given them. The question in my mind is that, okay, if the parent who has the kids for most of the time delegates it to the grandparents, and the grandparents live in Florida, and so they take the kids to Florida, and then the other parent has the ability to see them on weekends or on 2 weeks, whatever, but they're so far away now. Is it incumbent upon those grandparents to like bring the kids back? Or how does that happen when the people that are delegated are not in the same, who've gotten the authority to watch the kids? What if they're somewhere else? Is it incumbent upon that non-delegating parent now to travel to see their kids? I'm not sure how that works.
Beth, can you help us on
Mr.
that front?
Chairman,
Yeah.
Senator Pappas, I do think I understand your question. It's a very good question. And the way that would work under this bill is that essentially, yes, those grandparents would have to uphold that custody and visitation agreement that has been ordered by the court because they're stepping in to that role. That parent has essentially delegated that role to those grandparents. So yes, they would have to ensure that visitation piece was met. However, it had been ordered by the court, which again, probably in reality, then those grandparents would not be able to be that person. And again, I would say, I would assume, if both parents were living in Cheyenne, that other parent would just be the one to step up. But again, we need to be sure that parent knows that someone is delegating to someone else so that they can do that, exactly that, and potentially just step into that primary role.
Follow up, Senator? You good?
No, I'm good. Yeah, thank you.
So Beth, a couple of things come to mind, and I guess my question, it looks like on the top of page 3 that we nail that down pretty well. I mean, the delegatee, there's some real restrictions there. The delegating parent's own parental authority regarding care and custody of the child, and the delegatee shall only make day-to-day decisions, shall not be able to make decisions that would impact major issues such as changes code, If a parent is present to make decisions for the child, the delegatee may not interfere. I guess that's still, if we can bring the notification into this bill and we can make sure that there's consent of another parent, but that piece right there makes me wonder, do we need the consent of the other parent? Because it feels like this is written pretty tightly there. Can you help me with that?
Yes, thank you, Mr. Chairman. And I will say that the C1 is certainly a large improvement from prior versions of this bill, such as the one last session. So I definitely appreciate that work. However, I would still say that both notice and consent would be proper for that other parent. If those were both in this bill, I would not have further concerns. Those are the two main pieces that I see as missing.
Okay, I'll come back to a couple of things. Senator Pappas.
Yeah, you just said notice and consent.
Mhm.
I have an issue, I think, with that. I think I don't have a problem with notice, but I don't think consent is necessary or even because in some situations, they're not going to even be sometimes even talking to each other except for the transfer of the children. And so one parent is just not going to consent. I can see that in many instances because they hate each other. So I see notification, but I don't think that the non-delegating parent has to consent to transfer of parental authority because they don't have any authority for that portion of their custody, right? They shouldn't have to be able to consent.
How do you feel about that consent piece? Beth, maybe you can help. us
Mr.
there.
Chairman, thank you. And thank you for the question, Senator Pappas. I do think that the consent piece is necessary. I could see that a parent may say, that's fine, grandma and grandpa, your parents, my parents, whomever can take your visitation or your custody time, right? They may agree to that. But if they don't, then it's because I assume they are going to step in and take care of those children. Wherefore this whole document is unnecessary. So I think either they should be consenting as a parent as to who may care for their child in their absence, because again, it's their absence as well as the other parent's absence. And so typically I think that yes, parents have that right individually to determine who cares for their children.
So Beth,
Okay.
and therein lies the problem, doesn't it? I mean, the question I would have for you is, don't you think that's why this bill was written and is sitting in front of us? Is because what I just heard you say, and you even indicated earlier that within 72 hours, we can get something resolved for you. That's if I can find you. And I know that you're the best child attorney in the state of Wyoming, and I'm looking for you. And by golly, then it can, in 72 hours, you can help me. What if we don't have that kind of time? That's what Senator McEwen was indicating. Some of this stuff has to happen fairly quickly. And I guess that to me is why this bill kind of came about. Tell you what, I guess that's not a question, but I would appreciate your thoughts on that because I think sometimes our law can get ground down into, it can be as bureaucratic as the state government, and pretty soon you're going, well, we can't get anything done here. If we're going to demand the consent piece, aren't there times where you can't get that consent?
Mr. Chairman, potentially, but again, we're talking about a bill. In this bill, we're talking about delegating that authority for up to 2 years in some instances. So while I can certainly appreciate how these deployments can come across quickly and people can be required to deploy quickly, certainly as was indicated by the major that spoke earlier, that's why common law essentially would recognize such a power of attorney really already. And it is for those pieces, right? You're essentially having someone watch your child for potentially a short period of time until a more formal process can take place. And so that would be my position is I understand notice and or consent, whatever this body feels may add to this bill. would potentially take time. But I think when we're talking about something like a delegation of up to 2 years of a child's life, I think that it is worth doing the process correctly and making sure that even if it does take a little extra time, that that's important.
So would you be willing, because this is a bill that's been worked for 2 years and during the interim, it passed our committee unanimously. Would you be willing, if the committee still wants to go forward with this bill, would you be willing to work with me, work with us to come up with a couple of pieces that we could then look at to amend into the bill?
Yes, Mr. Chairman, I would be happy to.
Okay.
do that.
Committee, any other questions for Beth? Really do appreciate you being here, but thank you for we
Yes.
were not aware of these concerns, and so it's very helpful to us.
I appreciate that.
yeah.
Yes. Thank you, Mr. Chairman.
Yeah, thank you. Okay, do we have any further public testimony on parental authority? Senate File 13. Mr. Smith.
Thank you, Mr. Chairman. Chris Smith, Senior Counsel for the Wyoming Military Department. I feel like I have to be really blunt. If you're going to put consent in there, we don't want the bill. Because we're talking about people who it's temporary. The bill already says if an existing parent comes in, they win. They get
trump
to
it.
take the kid. The bill says nothing about any existing custody arrangement can be changed by a temporary delegation. We're literally what we do with our deployers. And I've been doing this for 28 years. We make them ahead of time, come up with the emergency. Who's going to take your kids if you have to go out the door right now? The non-custodial parent could be in Alaska. They could be anywhere, but we need somebody right now to take care of your kids. That's what we're worried about. We then tell them, and somebody who isn't prepared to have the kids, we're talking about school problems, everything else. We want you to have a more longer term. If the non-custodial parent does not come and pick up the kids, who's going to take them? So we usually have 2 stages. We have one power of attorney for right now, you're going out the door. It needs to be a neighbor. It needs to be somebody else in the unit not deploying. It needs to be a spouse of a deployer. Because right now, somebody's got to take care of your kids, right? Because you're leaving now, as Mr. Winnie mentioned. Then we have the second power of attorney, often the same, but not always, that until the other parent can come and pick up the kids, if they want to, they may not want to, they may not be able to, who's going to take care of them so that the child is not jerked out of the school or done anything else. If we're going to require consent, literally don't want the bill. We'll keep doing what we've been doing for 28 years. It's just not worth it. Notice, I assume the parents talk. I assume there's some conversation there. If you want to put that in the bill, we can look at the language. But again, I want to do everything we can to make life for our deployers less complicated. I don't want somebody to say, well, I never got notice. Well, they sent you an email. Well, how can you prove that? They're overseas right now in combat. I just worry that, we're going to unduly complicate this. And as Major Hinkle mentioned, common law, Wyoming has always allowed these things. I've talked to people about using them. Sometimes we have to kind of cajole them into allowing the power of attorney to go forward. I just didn't want the committee to get too far down the road. And the last thing I'll mention, Ms. Lance mentioned guardianship, and that's the last thing any parent wants to be involved in. To have a court-ordered guardianship, that takes a court order to end it. You don't ever want to touch a guardianship, in my opinion, unless it's necessary for the good of the person who's going to be the ward of the guardianship. So that's all I wanted to say, and I stand for the committee's questions.
No, I appreciate that, Mr. Smith. Questions for the Military Department Council? Anything? Thank you. Come on forward. Mr. Winnie, you bet.
Yes, sir, Mr. Chairman, Bill Winnie again, Sublette County. Just to touch on the Navy side of things, where you have a single parent with 100% custody, that topic has come up here. The Navy requires to have them in place all the time, procedure, custodial documents, however you would call it, so that if they do have to go on short notice, the paperwork is there. That's for your 100% custody single parent. In other words, the other spouse isn't around where you can just say, take care of them. So that's a Navy side of the topic. I presume they're probably pretty close in similar documents, subject to your questions.
Thanks, Mr. Winnie. Appreciate it. Anybody else from the public? Anybody, any other public comment? Okay. Anybody online tonight, Kim? By any chance?
Mr.
Donna?
Chairman, there are no
We're good.
people in the waiting room.
Okay, I'm going to close public testimony. What's your pleasure, committee, on this bill? Okay, moved by Senator Pappas. Do I have a second? Second by Senator Anderson. Let's work the bill, committee. Anything on page 1? Is there anything on page 2? Senator Pappas.
Yeah, I think we can take a stab at the notification thing. I am not, I don't want to do any consent, okay? That's not, as when we were talking with Beth about consent, that's just not going to happen. And I agree with what we heard from the military department. If we put consent in there, I won't vote for the bill. But notification, if I was in a custody situation, a shared custody situation, I think it's only good to attempt at least notification. And I wrote an amendment here that maybe we could, do you want me to share it with you right now?
Absolutely.
Okay,
Gosh,
so
yeah,
so I was thinking
what kind of-
probably on the end of line 9, we could say something like this, and I might ask the military department to tweak it because it does say shall, and maybe we don't want to use shall, maybe we need to, maybe it should be attempt. But so I said, I wrote down, in the case of shared custody, notification to the non-delegating parent shall be made prior to the delegatee assuming parental authority. But that shall means, that means that you've got to really contact. What happens if you can't contact that person? So maybe it is an attempt shall be made. I don't know. Maybe the legal minds could help me there.
Thank you, Major. I like where the senator's going because I have appreciated the comments from our attorney that represents people who do this for a living. And so what can we do with that language that might get us to a place that we don't wreck the boat?
Mr. Chairman, and I apologize, Senator Pappas, I didn't have a chance to write down what your
Okay.
proposed language was.
I'll go over it again. Okay. The sentence would be, in cases of shared custody, notification to the non-delegating parent shall be made prior to the delegatee assuming parental authority. Now, my question is, when I say shall be made, does that mean, if you can't get a hold of that person, if they're not reachable, then have you made notification? No, you haven't, right? So that may tie your hands. And so I think that language needs to be tweaked.
So
I'm
Major,
I'm
what's your
looking for help.
reaction to that language? I like the amendment. I'm with the senator. I'm not sure about the word shall because it might get us tied into knots. What's your thoughts?
Mr. Chairman and Senator Pappas, I think the shall, from a logistical standpoint, could be very difficult depending on timeframes, communication methods between the two folks that we're talking about, state differences, time zones. If somebody's overseas, that complicates things further. I'm sitting here thinking through what an option might be.
If we say attempt shall be made, well, that's subjective and yeah, maybe every attempt shall be made to contact.
I don't know if that's specific enough.
And
Well, why couldn't you just do the shall be attempted before the custody? In case of shared custody notification.
Every attempt or every.
it may not be strong enough, Senator Anderson, is my concern.
Hmm.
That may not be quite strong enough. What do you think?
Mr. Chairman, we had a suggestion, perhaps to put in a requirement that notification be made within so many days of the delegatee assuming that authority under the power of attorney. So I'm not exactly sure how to word that because I'm chicken scratching here, but so rather than doing the notification in advance, because the timelines may not permit that, as long as it's made within a certain period of time after the person has assumed authority, that would still satisfy the requirement. It would put the other custodial parent on notice that if they want to come and get the child in that circumstance, they could. And that might alleviate some of the concerns that Ms. Lance raised earlier.
Can you state that again, just to
So-
make sure that Senator Pappas, he's doing a good job of getting this amendment sharpened up here.
Certainly, Mr.
Yeah.
Chairman. I just said something about notification made within so many days of the delegatee assuming the authority. That's probably not perfect, Senator Pappas, so my apologies.
So the question is, I like that. The question is, Mr. Chairman, is what that timeline, would it be 15 days? Would it be 30 days? Would it, I don't know what, I don't know, maybe someone would have
Mr. Chairman.
Beth has got her hand up.
Beth, you're absolutely fine to come forward. Absolutely. Yeah, not a problem. And Major, you can stay up here too. So I'll get to the senator in just a second. This is just fine, you guys. This is a little bill that if it's to go, it's just got to be right.
I
Okay?
appreciate that, Mr.
Yeah,
Chairman.
so
And
Beth, do you understand what the situation, and here's the deal. I understand that it's not just military.
I
I
know.
get that. And so that, the real world's a little different than this world of the military.
Mhm.
But anyway, what are your thoughts?
So typically, in the legal realm, notification is done through the Wyoming Rules of Civil Procedure. And there's a whole very specific procedure there about process service. But I also understand, particularly for the military, I would just suggest that maybe that be carved out the same way this bill carves out 2 years for military members, that the notice not have to necessarily be provided prior to being able to execute, particularly for military. I do think that's what we're looking at, how they're a different group here. And so I understand that, and I would say 60 days, maybe 90 days, that notice be provided to that other parent in accordance with the rules of civil procedure within that amount of time. But that they would go ahead and execute so that they can be deployed. And so I understand what they're looking at.
I guess I'm trying to figure out, Beth, how we can carve this into just a military bill only. It's come all the way to the session and here we are. And, we might have had a shot at that during the summer, but that's a pretty tough lift at this point in time. So, but 90 days seems a little bit long, but civil procedure calls for, that allows.
Oh,
maybe
civil procedure would require notification prior to moving forward with any legal action. But this isn't a complaint, right? So this isn't, no one's
Right.
suing anyone.
Right.
So we're looking at something else entirely. But the reason I bring up the rules of civil procedure is then we do have specific instructions on what is notice and how that may be accomplished. That's the reason I bring that up, because it's something that already exists that someone can look at and understand, okay, this is what I need to do. And once I've done that, I have provided actual notice. So that's the reason I bring that up. Just as another point of clarification, I would just say that it is a term of art to say shared custody in the state of Wyoming. If you say shared custody, you are referring to parents who have a 50-50 custodial arrangement only. So I believe, Mr. Chairman, what Senator Pappas probably intends is the term joint legal custody. And that is a separate term of art in the state of Wyoming, which means two parents, regardless of the custodial arrangement, that still have parental rights to the child.
Thank you for that. Thank you. Very helpful. I think that the danger, I think I speak for the committee because we worked this for a while. I think what makes us a little nervous is that we don't want to bog down in a whole lot of rigmarole in these kind of situations. They're pretty specific and temporary but anyway, appreciate that. When we start talking about referring to other things, it just sort of muddies the water a little. But we can work it. I mean, we can continue to work this. I don't think we're close to that at all. I don't know how we can separate you guys, the military need that we may or may have here versus, I get it. It throws a blanket over everything. So Senator Pappas,
Can I take a stab at another sentence?
do a green for me, would you please?
Can I take a stab at another sentence? So what if we say, in cases of joint legal custody for a parent who is a member of any branch or service of the military, notifications to the non-delegating parent shall be made within 30 days of the delegatee assuming parental authority. Sound any better?
Senator Pappas, that actually sounds pretty good. That carves out
Because
this military piece.
What I heard is that from both sides here, we need to get the 30 days maybe in there and not what I had before, shall. But I also heard that it only needed to be for military people, right? For the military, not everybody else. So I threw that in there, but I think it still has to be in paragraph A. Am I correct there? Because only paragraph B talks about military members. So we have to put it at the end of paragraph A, if I'm not mistaken, correct?
Mr. Chairman,
Yeah.
I believe that notification is important regardless if a person's in the military or not. So I would still suggest that notification to the other parent be included. But what I was saying is I understand that a military member may need time. They may need this to go into effect prior to the notification. I would suggest that notification in other circumstances occur prior to this going into effect, if that makes sense. And I would say that potentially a notice piece should be a new letter. I would almost just add a new paragraph, which explains notification in each circumstance.
And encompass both circumstances.
Right.
Just somebody in the community versus a member of the military. I think that's probably a good idea. I would pledge this. If this bill moves forward, and it is a committee bill that had a lot of support, we don't need to go anywhere with that for a day or two. I would be willing to work with both of you to see if we can't get somewhere with this bill where we've got a little more comfort. And we don't have to put this on committee of the whole until we like it, or we like what we think we can do to it. Does that make sense? And if you're willing to do that, Beth, Major, we could go to work on this, huh? I like kind of where we're heading. There's probably a couple other spots in the bill, and I would challenge Beth, if you would help us with that, to see if we can identify anything else where we might have a little bit of a trap. We'll see if we can get the bill better, huh? We're just not, I think it takes the expertise of our legal eagles here in front of us committee in order to get that language exactly right. And we can bring that as a committee of the whole amendment. What do you think?
Yeah, Mr. Chairman, might I
Senator
suggest if they're going to work on it, that perhaps it ought to be in paragraph C and then everything renumbered. I think that's the location it should be.
I think that's a good
And I agree,
suggestion.
because then it would, all of that would apply to all the other paragraphs A and B as well. So thank you, Beth.
If we could take a look in the next day or so at this bill one more time, see if we can clean it up a little better with a couple of amendments, I'd sure appreciate it, you guys. And if you reach out, if you have a time that works, I'll try to make it work too. So maybe, go ahead, Senator
Mr. Chairman,
Pappas.
are you suggesting for tonight that we just table it and we take it to the next meeting? Work on it between then, not take a vote on it tonight? Is that what you're suggesting?
That is an option. I was actually gonna take a vote on the bill, but we could push this forward. to,
I would rather clean the bill and then pass it like we like it. I just soon table it till the next meeting.
Okay, that is a motion, by the way, that doesn't need a second, and it doesn't get any debate. So this one is tabled, and let's go to work on it, you guys. I think there's still potential for this bill. The piece that I like is that it may help a member of the military in particular. And Beth, maybe it gives a little bit of an easier option in day-to-day life out there that might help one of our citizens too. If we could find that sweet spot, that would be great. So I will try to notice you guys, if you two can put your heads together and pick a time. Any one of us who can sit in with you will do that. I will definitely be there because I'd like to work this bill. And so thank you very much, both of you.
Mr. Chairman,
Senator Pappas.
can we plan to get it done by Wednesday night?
Let's take up this bill again on Wednesday night. It'll be the first one up, and hopefully we'll have some things that we can put a little frosting on the cake. Okay. All right. Well, Senator McEwen, give me a green, would you? Attaboy.
As we start heading down this path to finalize this bill and make it fit everything, it reminds me of one of my favorite statements in the Army. Perfection is the enemy of good enough. We're going to make it so complicated that we're going to miss the whole mark. At the time I was assigned to 18th Airborne Corps, we had this fun little exercise called Green Ramp. That's a 2-hour notification. Your stuff's packed down at the airfield and you got to go. And the other point I want to bring up is I would like to help when we look at this. And I would ask Major Hinkle, could you bring a copy, a blank copy, obviously, of your pre-deployment paperwork? I don't know if we have an appreciation for the time and effort put into that. And when you're filling it out, I know where I was, and I'm sure the Wyoming Guard isn't any different. There's a JAG officer present. And if there's a divorce decree, that attorney goes through everything with you and helps you fill out the paperwork to protect both you, the child, and maybe the other spouse. So I go back to if I don't do it, I've been advised and I'm choosing to do something illegal.
Well, certainly, let's work that bill and make sure that doesn't happen, Senator. I appreciate your thoughts, and let's try to lean into it, and we'll see if we can get this bill where it needs to go. That's kind of how this process works, and appreciate you guys. Thanks, everybody, for being here and spending a little bit of time on this bill. I think it's worth it, hopefully, and we'll see you all on the next couple of days sometime, okay? Thank you.